Good afternoon. My name is Jorge Molina, your immigration attorney. Today, I have the great pleasure of speaking to you about the U.S. Citizenship Act of 2021, Comprehensive Immigration Reform. We have a lot of subject matter to cover, so I'm going to jump right into the presentation. And then, if you have any questions, you can type them up in the chat box or just save them till the end. We'll open it up for a few minutes for questions. And then this recording will be available to you in our website as well, later today or tomorrow. So here we go. I'm going to share my screen. Share. There we are. There we go. All right, folks. So as we always do, we preempt this webinars by saying that the information that we're going to share today is based on information available to us as of this date. Very likely, what we're going to say is not going to be exactly what happens. First, this law needs to pass, and second, it's likely that maybe just certain pieces of it pass Congress, or if bigger aspects pass, will have significant amendments. So everything's subject to change, and we will keep you updated. We'll let you know what's going on. But just remember, this is based on information we have as of today. The bill was revealed to us about a week ago on Thursday. It's about 350 pages. I read it all, and I summarized this and outlined it, so you don't have to. The way that I organize this presentation doesn't really follow exactly how it is written in the law, but I've organized it in a way that's easier to understand and absorb. But in essence, we're going to talk about the new ways to get a green card. Then we're going to talk about how the current system is being overhauled or reformed. And then we'll talk about specific changes in the immigration court system, employment-based immigrations, and what the United States will do to address the root causes of immigration, particularly irregular immigration from Central America. But it's clear, it's evident from the text, the purpose, the vision. It's a new era. You can really sense that the authors of the bill have a much more mature, complete, nuanced understanding of the immigration system of the United States, the root causes of immigration, and the pain that people are going through and experience because of the archaic laws that we currently have. So it's a welcome bill. It's a great start. It's not perfect. We have a lot of other issues to resolve and solve, but this is certainly a marked difference from previous laws. So where IRA 1996, the purpose and the feel to it was to punish irregular immigration. Here, the sense is to fix the problem, right? It's not just centered in punishment, but in solutions. So again, that's a welcome change. And one of the best examples is a change of the term alien. Now, the law won't use the term alien anymore. It will be non-citizens. And the reason for this is a recognition that the term alien is now a loaded word. It has certain other connotations that weren't intended when the term was first adopted, right? So this term the term alien has been in use since the founding of the country. Now will be changed to non-citizen. So that's just the very first example. But let's jump right into it. So what the law does, or the big new thing, is that it creates a new category of would-be immigrants. So this is a new status, and it is that of prospective immigrants. So in that status would be valid for 6 years. It applies. The application process is for entire family units, right? So it's not an individualized process. If your spouse or children under 21, you know, if you qualify, your spouse and children under 21 would too, right? And they will be part of your application. Importantly, with this status, you're allowed to work and you could travel outside the United States as long as you don't last over 180 days outside the US, and you're also allowed to join the armed forces. Importantly, you're excluded from certain public benefits. So, the ACA, the Affordable Care Act, Social Security benefits, stuff like that. But once you're in this prospective immigrant status for over 5 years, you would be eligible to apply for adjustment of status, right? But again, you need to pass certain other things. For example, a background check, not had been waived for over 180 days, right? And you must remain eligible to be a prospective immigrant. So, $1 million question here: who is eligible for this? So there's 3 categories. Okay, so there's dreamers, TPS or DED holders, and agricultural workers. All right, so let's jump right into the DREAM Act. Here we see a certain similarities with DACA, but also some changes. Okay, it feels that it's somewhat more stringent and strict than DACA. But we also see some other changes, and it makes sense that they would require additional matters. So for example, whereas DACA is for individuals who entered the United States under 16 years old, here it's 18 years old at the time of initial entry. And similarly, you would have to complete either a high school diploma or GED. But unlike DACA, here they're asking for higher education. So higher education could be college, vocational school, technical school, anything like that. And then to serve in the quote-unquote uniformed forces or have income for 3 years and register for selective services. So about the selective service, just a reminder that if you're a male between the ages of 18 and 26 years old in the United States, regardless of your immigration status, it is a requirement for you to register for selective services. Now, there's another reason why you might want to do that, and remember that. Again, this is a family application process, so if someone is married and qualifies and has children or a spouse that wouldn't qualify for anything else, the entire family would benefit from this. Importantly, so the law doesn't really specify how it's streamlined the process for current DACA recipients. We're going to have to see the final bill and then the regulations to know how it's going to benefit. But clearly, DACA beneficiaries are a privileged class here. It's identified by law that they're going to get a faster process. So, importantly, if you qualify for DACA under the terms of 2012, the initial announcement, you should apply for DACA so you could benefit from this. All right, so I'm going to talk to you about some technical terms, but these terms apply for dreamers, agricultural workers, and TPS holders, right, which we're going to be talking about in a few minutes. But there's a certain eligibility criteria under 245 GB. I'm going to go over the details right now, but in the future we're just going to say 245 GB criteria. This means that the person must be present in the United States to apply. Continuously lived in the United States since January 1st, 2021. So that's the time limitation applicable to all these new green card paths for these categories. And then importantly, some grounds of inadmissibility apply. Not the entire immigration code, but certain grounds of inadmissibility for these new categories. So importantly, criminal activity, national security, and terrorism bar, non-citizen smuggling, draft dodgers, international child abductors, if you kidnapped a child to prevent custodial, or custody for a parent, and then former citizens that renounce U.S. citizenship to avoid paying taxes. So those people, those grounds of inadmissibility still apply. There's waivers available except for national security and terrorism threats and aggravated felonies. All right. There's a new also bar, and it's a 3 or more misdemeanor bar. There is a waiver available, but if you have 3 or more misdemeanors, it's going to be harder. You need to talk to a qualified immigration attorney. Each situation is different, but there's waivers available. So it really depends on what you're getting. So this criteria will apply for other things. So we're going to be referring to this repeatedly. All right. So 245GB. All right. So that's the DREAM Act. The next new way is the American Promise Act. So in essence, it is people with TPS or deferred enforced departure. So, we're talking about people from various countries in Central America, Liberia, and among other countries. And then DED holders now, as many people know, DED was announced for Venezuelans. The criteria here, the key thing to remember is that for you to benefit from this, you must have been continuously present in the United States since 3 years ago, or 4 years ago, January 1st, 2017. All right, so that's a key date. And then you must be a TPS or deferred enforcement departure holder. Again, similarly, like under the DREAM Act, it's a family application process. So if someone qualifies, the father, mother, someone like that qualifies, children could, and the spouse could as well. And then it's just one application per family. Importantly, now TPS means, for immigration purposes, being lawfully admitted to the United States. What does that mean? Or why is it so important? Because even if you enter the United States without inspection, you didn't have a visa come in, and you have TPS, now you can adjust status in the United States. You don't need to leave the U.S., go to your country of origin, and then come back, which is, it's an increased cost, and then it's more risky because you could face, certain issues that will just keep you there, and you're going to have to fight your case from your country of origin. So now TPS equals admission. And there's a lot of litigation and re-evaluation of the law and the reinterpretation of decisions and stuff like that. So this is a welcome change that clarifies the definition. All right, so the third category is for agricultural workers. So, same thing with the eligibility under 245GB. Grants of inadmissibility to apply, continuous presence, and you must apply and be in the United States. But in addition to that, you need to show that in the last 5 years, from the time that you apply, you worked 2,300 hours or 400 work days. Importantly, and again, this is just based on my interpretation, right? The text of the law says 5 years from the date of application, and it doesn't give you a cutoff date of when the person should have started working. So arguably, you can start working on the in agriculture currently, complete, the 400 work days, about, a year and a few months, and then apply. So, that's strategy. If you're interested in that field, then you could, be willing to do the work, something you could do. And again, this is a family application process. All right, so those were the new ways to get a green card. I think it's a great start, but I think more profoundly, there's some major changes that are much needed, and because of the current laws have created a lot of pain and separation among families, um, and it hasn't really served the public interest. So importantly, we have a new waiver. So the section 212C of the INA is put back in place, but it's a little different from the waiver we had before. Um, Importantly, there is no extreme hardship analysis. Instead, what we have is consideration for humanitarian purposes, ensuring family unity, or whether waiving someone's ground of inadmissibility is in the public interest. As in the cancellation of removal context, the factors to consider if someone has, a ground of inadmissibility is how severe the offense is, how much harm did you cause, the time that the person has lived in the United States, rehabilitation, right? So how long has it been since you committed the offense? Have you learned from this? Are you, remorseful? And then how it would adversely affect the non-citizen or his relatives. Now, this is a marked change from previous waivers, because in all the immigration law contexts, rarely was a hardship to the immigrant considered. It was mostly their relatives, or and more often than not, the immediate relatives. But now we can, with this waiver, you can consider the hardship to the immigrant himself. Again, importantly, this is not applicable for aggravated felonies or security-related crimes, right? So that remains the same, and then those individuals are actually priorities for deportation in the United States. And this waiver is also available in deportation proceedings, so which is a great help. Importantly, and notably, actually, they are resurrecting the V visas. So in the late 90s, early 2000s, we had this program where, if you file a family petition but it's been pending for a while, your relatives could enter the United States, work lawfully in the United States while the immigrant visa was being processed or the date became current. That was a lot of help for our thousands of families. So we're resurrecting that program. And what has to happen is that the family petition must be filed and must have been pending or approved, but the immigrant visa is not yet available for 3 years. So with that, you're eligible to apply for a V visa, and then you can enter the United States and you're allowed to work. Notably, and importantly, and I think it's very reasonable, that these individuals are not eligible for public benefits in the U.S. Okay, other important changes. They're lowering the minimum amount of time that you have to be a lawful permanent resident from 5 years to 3 years if you continuously resided in the United States and you were eligible to work. Okay, so big change from 5 to 3 years. And then, and I cannot stress how big this change is. They're changing the definition of what is a conviction, right? So, to give you a few examples and to put it into context. So, if you were granted deferred education in Texas, or you entered a program in which you're going to take a few classes, you're on probation for a few years, but after you successfully complete everything, your case is dismissed by the court and there's no adjudication of guilt. That was and still is considered a conviction under immigration laws. regardless of whether the sentence was never imposed or it was set aside or something like that. Well, that's changing. Now, dismissed, expunged, deferred, annulled, invalidated, withheld, or vacated adjudications are no longer convictions for immigration purposes. That's a marked change. We've been seeing a lot of litigation and changes in the last 25 years because of that definition, so this is a welcome change. Um, Importantly, too, if a person is given a probation but no jail sentence is imposed, it doesn't count as a conviction. And then here they clarified that a sentence within the context of immigration law means a period of incarceration ordered by the court and does not include a suspended sentence. So in occasions, they'll say, this is your sentence, but we're gonna give you probation instead of the sentence. And if you complete the probation, we're gonna dismiss your case. Well, that will be a big help again. And then all these programs and ways of adjudicating criminal cases in state law that were done to really not harm someone permanently will now be in line with federal law, right? So because a lot of this probation and deferred adjudications and everything, the purpose of that is to allow a person to, rejoin society after they paid their debt. So, a lot of those changes started happening in the early 2000s. Now, we're going to have some conformity with that. And importantly, immigration authorities must abide by court recommendations to not remove or deport an individual. We frankly stopped seeing recommendations from courts in the 90s because they started realizing that it had no effect in the immigration law context. But very likely because of this change, we would start seeing judges, or recommend individuals to not be deported. Okay, another massive change is now that spouses and children under 21 years old of lawful permanent residents will be considered immediate relatives, meaning that an immigrant visa will be immediately available to those individuals. Also, importantly, they will now be eligible to adjust status in the United States even if they accrued unlawful presence, even if they are here without any legal status. As long as they have a lawful entry to the United States, they will be eligible to adjust status. So that's a tremendous help, and also, importantly, they won't be counted against the numerical limitations on immigration to the United States. Another welcome change. Importantly, and I mean, attorneys and people, in this world have been advocating for this for decades, the recapturing of unused visas. So what happens is that if you do not use a visa by operation of law, within 1 year, it's revoked, right? So currently, all those revoked visas are just lost, right? They're like in a limbo, they're revoked, the person that would have benefited can't use it, but no one else can. With the law passes, now we would be able to use those visas and apply them to other individuals. Another major change is a repeal of the 310 and permanent bars, right? So how does this currently work? If you're in the United States without lawful status for 6 months and you leave the U.S. after those 6 months, you're not allowed to return for 3 years. If you stay in the U.S. for over 1 year for unlawful status and you leave, you can't return for 10 years. There's waivers available for those two bars. They're difficult to get, but there's waivers available. Now, the permanent bar is you stay in the United States for over 1 year, left, and then try to re-enter unlawfully, or you successfully re-entered unlawfully. Now, you have a permanent bar, you must spend 10 years outside the United States and then reapply for lawful admissions. So we're getting rid of that. Also, there's a waiver. The 212C waiver would be available for people who made a false claim to citizenship, which is a welcome change because a false claim to citizenship was pretty much the death penalty in the immigration law context. Um, even if you just said you're a U.S. citizen to work, you wouldn't be able to adjust status. But now there's a waiver available and an exception. If you made the false claim to citizenship under 21 years old, it wouldn't be counted as an inadmissibility ground. So another welcome change. All right. Now, one of the biggest areas where we could improve the system and frankly needs reforms is in the immigration courts context. When I premised when I started talking about this, I said it was imperfect, and what I was really thinking about is the immigration court system. The law that doesn't really address all the issues, all the problems. It doesn't address some of the definitions that have been used in the immigration court system. But it's a welcome change. This is better than nothing, and I think that there's some important things in the law. So first, there's a change in the way that we process people. So instead of wanting to jail everyone and a bunch of detention centers popping all throughout rural areas in the United States, now the intent is to increase alternatives to detention. So whether it is to wear an ankle monitor or bracelet or check-ins or something like that, that would be something that the law would try to increase. Also, to address the immigration court backlogs, the goal is to increase by 55, or to increase the number of judges by 50, immigration judges by 55 in the next 4 years. So 55 in 2021, 55 in 2022, so on and so forth. And importantly, they want to balance who becomes an immigration judge. Not only do you have to be qualified, but it would be a marked change from previous administrations that, and famously or notoriously, the Obama administration hired mostly former government representatives, for example. So now they will try to balance who becomes an immigration judge between private sectors, government officials, and nonprofits. Importantly, the law also seeks to increase staffing for immigration courts and the Board of Immigration Appeals, and finally, electronic filing. Right, so increase electronic filing. Most other agencies and departments in the United States allow for electronic filing. I think the IRS has allowed electronic filing since 1988, and the immigration courts are, comically, it would be funnier if it was so serious, but they're still trying it out. So that's a welcome change. Also, the realization that legal orientation programs actually help everybody involved understand their rights and how things should work, and everyone's better prepared, so they're implementing those and making it part of the law. Another major change is that now the government may appoint counsel to the respondent, to the immigrant. Currently, the law says that you can have an attorney with no expense to the government at no expense to the government. But now the law says that they can appoint counsel at government expense, and it mandates that certain classes of people have a government-appointed counsel. So these are, children, quote-unquote, particularly vulnerable individuals with disabilities, victims of abuse, torture, or violence, pregnant or lactating women, and parents of United States citizens, minors. I think that's one of the biggest changes. It's surprising that's in there. So in essence, a big portion of people applying for non-cancellation, for non-lawful resident cancellation of removal, would be eligible for free representation at government expense. So that's a big change. Running out of time, I also want to save some time for questions at the end. But importantly, there won't be, excuse me, there will not be a time limit to file asylum applications. Currently, we have 1 year to file an asylum application, or we forego the opportunity to file for asylum. But this law, if it passes, will get rid of that limitation. And then it's increasing the U visas available a year from 10,000 to 30,000, which is massive because we have about a 14-year backlog in U visas. So we have about over 140,000 U visa cases pending. So this is a welcome change again. And then work permits for asylum seekers should be processed under 180 days. Again, another welcome change, marked difference from the previous administration. All right, so for employment-based reform, there's a lot of important things. So the main one, in my view, is that there's no more per country limitation. So right now, there's a number of employment-based visas available to individuals. But if you're an individual from China or India or some other countries, you're limited by national origin. So what ends up happening is that most people, or a lot of the people applying for employment-based visas, are from India and China. And because of their nationality, even though that there's employment-based immigrants visas available in other categories, they're not allowed to, and the wait time is over 10 years. So they're getting rid of that country limitations. This was a very touchy subject because it pivoted different interest groups against each other that all wanted immigration reform. So this is a great solution to that issue. Also importantly, if you have a PhD from a United States university, you're not subject to cap limitations, meaning pretty much you're sort of like an immediate relative immigrant, meaning that there's an immigrant visa immediately available to you. So all you would have to do is just get an employer to sponsor you and go through the process, and then you're a lawful resident. Big change. There's also protections that they're long overdue for children of individuals that enter in fiance visas and H-1Bs. Currently, they're allowed to age out. So if you don't file an adjustment of status application before they turn 21 years old, they're not eligible to adjust status. So this is a change that is long overdue, and many people need the protection. The law also increased the employment-based visas and how you calculate that number. And then there's 10,000 immigrant visas for economic development. It's not the EB-5 program, it's a new program, so again, it's a welcome change. All right, and I think one of the more ambitious part of this bill, and frankly insightful, is that it seeks to address the root causes of immigration to the United States, or irregular immigration. And it recognizes what is a driving force of irregular immigration to the United States. And it does some important things to ease the pain and then to help the people that can be helped. So we stop seeing caravans or minors traveling from Central America all the way to the United States. It has a lot of programs that are intended to deter that sort of immigration. So, importantly, there's a part that pretty much prohibits Trump-style bans. No more Muslim bans, or as of this day, so and so can't come into the United States. That's changed in the law, and it's very clear. It also importantly introduces the child's best interest standard. This is a standard that we see routinely in the family law context. And as the standard suggests, we need to consider the child's best interest. So what does this mean? That likely we won't see the separation of children from their parents. We still have about 500 children that haven't been reunited from with their families or relatives since they were separated by the Trump administration. I think it's something atrocious, unforgivable, um, that they did that, but ideally with this new law, that won't happen again. Um, the law also resurrects the Central American minors program, so pretty much children, by children I mean sons and daughters under 21 years old of individuals with lawful status in the U.S. So whether it's DD, TPS, DACA, whatever, or well, not DACA, but any other status, lawful permanent residence, TPS or DD, you could petition your child from your country of origin. Again, you have to be from the Northern Triangle, Honduras, Guatemala, El Salvador. But, we're resurrecting this program. And we're doing it by law, not by regulation or policy, it's a welcome change. Also, it's introducing the Central American Family Reunification Parole Program, similar to the V non-immigrant parole system. And, but it's limited to the Northern Triangle. And then it's individuals with immigrant petitions filed for them that are not eligible yet. So who would benefit here? So siblings of U.S. citizens, adult children of lawful residents, or United States citizens, right? So, and among other groups. All right, so addressing the root causes of immigration. This bill is not just to help the people and ease the plight of families in the United States, but to address the problem at its root. And for that, it aims to promote the rule of law in Central America and to promote economic prosperity, combat corruption, and then importantly, it names, what are the main drivers of irregular immigration to the United States: gangs, extortion, violence, and then also sexual, gender-based, and domestic violence. Those are the main drivers of people seeking asylum in the United States. So, they named them, they pointed out the losses that we want to decrease this and confront it. And for this, it assigned $1 billion for this program. All right, so there's a lot more in the law. I cannot really go into great detail. We like to keep these webinars short, so you stay tuned. But it's a great beginning, right? So it's a big project. We hope that it passes. It could or certain things could pass, and others could be abandoned. But it's a no-brainer. This is a good start. Again, it's not perfect, but we'll see what happens, and we're going to keep you posted. So I'm going to end the presentation and then open the Q&A time. All right, so we get this question a lot. Has there been any updates on DED for Venezuelans? Currently, no updates. They have not published the regulations in the Federal Registry, which is the first step to see how it would be managed. But we expect big changes in March. So stay tuned. And again, I have a list of people I need to call as soon as the announcement is passes, and then we're going to do a webinar specifically for that. But stay tuned. We'll let you know as soon as it's ready. Okay, so just to clarify, okay, the bar of inadmissibility for 10 years is removed. You do not need a waiver anymore. So, for example, you entered unlawfully in the United States about 20 years ago. Then you met your wife, and she's a U.S. citizen. You have children. You're the main provider. currently what you have to do is, your wife can petition you, but you're going to have to also request a waiver of inadmissibility, and then go to your home country, and then if there's any other issue in your record, that waiver is going to be removed. You're going to stay there. They're going to have to file waivers again. Well, that bar is removed. Also importantly, the permanent bar, where you entered unlawfully to the United States, stayed here for over 1 year, left the U.S. and then came back, is removed. So that's a big thing. With that permanent bar, what you have to do is stay 10 years, your country of origin or outside the United States, and then apply for another waiver to come back in. But, well, the law changes that. All right, folks, I went a little over. Okay, we have a few here. So how would the U.S. promote the rule of law in Central America? Great question. There's a lot of details on this. So first off, the Secretary of State, together with the Department of Homeland Security and other cabinet positions, must start a strategy. Then once they have the strategy, they also need to coordinate with local partners, right, in Central America and everything. But one of the things that they aim to do is just strengthen the judiciary, the police, combat organized crime and corruption. So, there's a lot in the law about that. Well, and also needs coordination with local governments, but those are the key things that they seek to do. Okay, so we have a question. So says the question is, if I'm over 21 years old and married, and can my father petition me? So the answer is yes. You can be petitioned, but depending on the other circumstances, how you entered the United States and all those things, you could be petitioned by your parent. Here in this context, you just and let's assume that you won't qualify for the DREAM Act or agricultural workers or TPS. The issue here is that you wouldn't be currently under that category. You're not considered an immediate relative because you're a married child over 21. So your father could petition you. The issue is that the adjustment of status provision that would apply to you requires that you maintain lawful status during the entire pendency of the case of your stay in the United States. So you could apply, father could petition, but you wouldn't have lawful status, and therefore you wouldn't be eligible to adjust status under 245A. So, very good question there. However, you could adjust status, but you could potentially do consular processing. And then if there's no criminal grounds or anything, you would finish your process in your country of origin instead of doing it in the United States. So it'll be a little, harder, but you would be able to adjust your status or fix your status at that point. All right, folks, again, my name is Jorge Molina. It's a pleasure talking to you about this subject. If you couldn't ask any questions and you're a client, you can always send me an email. You already have my email. If you're not a client, you can send us an email at info@jmolinalawfirm.com. Our phone number is 469-708-5800, and it'll be our honor to assist you. Again, my name is Jorge Molina. Thank you for watching.